Welcome to What to Do When, a podcast from real lawyers with real perspective, where we explore a variety of legal issues and scenarios. Each week, we focus on a new topic and discuss what to do when and if any of these legal scenarios ever happen to you or a loved one. With over 40 years of combined legal experience, our hosts offer their unique perspectives and insights on a range of real-life legal situations.
Hi, welcome back to Critzer Cardani's podcast here in Richmond, Virginia. I'm Jackie.
I'm Scott. Jackie, what's on the docket for today?
What to do when you are posting online.
Ooh, hot topic, huh?
Broad topic, right?
Broad topic, yeah. So, Jackie, I think one of the biggest things people don't realize is that when you post anything online, words, pictures, thoughts, videos, once it's on the internet, it really never leaves the internet.
The digital footprint really isn't erasable. It can be buried, but not really erased, right?
Yeah, it's like Snapchat. Everybody thinks Snapchat because you snap it and it goes away, it's gone. But I've been in rooms watching police on case just watch the Snapchat roll by and taking videos as they need to. So, it's a misnomer and a real naivety to believe that you can post something online. And even is it Apple now that has a thing where you can erase your post? If you
post
the
text?
Wrong? Yeah, the text. I mean, that may or may not work. I can't say it doesn't work, but my point is, once you put it out there, it's usually out there. And all somebody has to do is screenshot it, capture it, it's there for life.
Well, so the next question is, when you do post something, thought, picture, video, anywhere. Let's just broad Facebook, Instagram, okay? Do you have any sort of reasonable expectation of privacy at that point? I know that sounds like kind of a dumb question, but if I post something on Facebook and I post it to friends only, okay? Is it reasonable that I have privacy?
My answer is no. I don't think it's reasonable at all. I think it's silly to believe that even if if I'm just posting a picture to you, I think once I put my thing out on Facebook, I know because their agreement says that they've looked at it and everybody in their building's looked at it. And then same thing with Twitter or X now or whatever it is. We know that the social media companies certainly are scanning every single thing you put out there. So if you think you're using a social media app and you have a reasonable expectation of privacy, I would say you're not thinking correctly because you don't. Now, we go to a text message. If I text you something, is there a reasonable expectation of privacy? I would say more likely, I think that's an okay expectation.
I don't know.
I still wouldn't trust it. I'm not saying I'd trust it. I'm just saying, is it a reasonable person's expectation that they would, if I sent you a picture, it's going to you? And that's, I don't know.
Well, so this goes back to some of the things we've talked about, but it'll also lead into other things. One of the things we've talked about is when your teenager is or anyone really is in receipt of pictures. Let's not deal with it being underage. It's college students, okay? Let's use that example. They're college students. They've received pictures from boyfriend, girlfriend, or maybe someone who wants to be a boyfriend or a girlfriend.
And these are usually nude we're talking about, unfortunately, but that's what we're talking about.
Some state of undress, right?
Yes.
And okay. And then your relative, your person, who the receiver of these photos or videos then disseminates them or publishes them or sends them to a friend or friends. Is that, what are we?
Yeah, that really gets into all these things. It really is a factual, contextual analysis, quite frankly. And, one of the things that's popped up here in Virginia recently is the delegate who's running who had a porn site with, I guess it's 5,700 subscribers, and the things that she did online got put out to the full public, and I guess her constituents will see how that is, by somebody else. And I don't know that we know the guy was a subscriber or not a subscriber. Honestly, we have no idea. I don't. Anyways, none of the reports I read had that in there. But
I think I'm not even familiar with what site that she had posted her videos to. I think what I know at this point is that she posted videos to a site. Somebody took those same videos that she posted and then reposted them somewhere else. Is that right?
Yeah, that's the gist of it. It was definitely on a social media platform.
Okay.
I would consider it a porn type site.
Okay.
That it was on.
Was it where other people also did the same thing?
Yes.
Okay.
For sure.
So,
from what I can tell, yeah, and it was, from what I understand, it was a kind of a paid subscription kind of thing where people could come onto the site and pay for a subscription to view that stuff. I don't know if it generally had a open forum where you didn't have to pay. I have no idea about all that.
and so then did she, or does anyone posting on such a site have a reasonable expectation that their posts, videos, pictures, or whatever of themselves, that now we're not even talking about someone else sort of it being sent to someone, but you personally posting it in a forum where other people can see it with on purpose. That's the intent of posting it wherever it's being posted. Is there a reasonable expectation, number one, that that's not going to be reposted? Maybe it's in the agreement, when you sign on to a site, maybe that's part of the agreement. You'll agree not to do that. So I don't know. I mean, that's the whole topic. Well, we don't know.
Well, and that's the biggest issue is, do you really believe that you have an expectation of privacy? I mean, in all honesty, I wouldn't believe that.
Sure.
I wouldn't think if I'm posting something for instance, say I message somebody in Facebook a video that I didn't want everybody to get out. I wouldn't do that because I wouldn't expect them not to repost it or show somebody or do something with it. By the very nature of me putting it out there, I kind of feel like that I should have an expectation of them sharing it.
More likely than not sharing it. Well, Scott, what does the law say about disseminating or spreading or reposting said things?
There's been a lot of topics with this. I don't know if she mentioned her name, but I think everybody knows her name. But the point is, there's been a lot of talk about revenge porn and her idea that the other side posting it in a political campaign was revenge porn, which is the site. But really the site is this, and I'm going to read it. I'm going to put my glasses on. Unlawfully disseminating or sale images of another is a penalty. So the crime is this, is 18.2, 368.2. Any person with the intent to coerce, harass, and intimidate maliciously disseminates, sells, or videographs or still any videograph or still image created by whatever means that depicts another person, all kinds of nude stuff there, is guilty of a class 1 misdemeanor.
Well, so we need to break that down, right?
Woo, yeah.
The intent to coerce, harass, or intimidate.
I think clearly, these words are very broad for a meaning, but I also think that there's a context to them at the same time. So coerce is that word. It means I'm trying to get you to do something. I'm trying to manipulate you. So, for instance, Jackie, if you don't do X, I'm going to send out that picture that you sent me. But remember, this is not the threat of sending it out. This is actually sending it out with the intent. So I don't know that coerce works that well in this kind of situation, because once you send it out, your expectation they're going to do something for you probably minimizes a great deal. And that's what I would argue in court is this is not coercion. But I can see that sending it to some person like my grandma, and I'm going to send it to the rest of your family may fall into that.
Well, coerce, okay, under Black's Law Dictionary. So and we use Black's Law Dictionary, not Webster's Dictionary, because most of these words in code sections are sometimes terms of art. And so they have a legal definition versus a regular definition. So coerce, Black's Law Dictionary, compelled to compliance, constrained to obedience or submission in a vigorous or forcible manner. Compelled to compliance. So exactly what you were saying, right? Do this. And it's not really blackmail. Blackmail is coercion, I suppose, but
yeah.
Okay. And then harass. What is harassment? This is a course of conduct directed at a specific person that causes substantial emotional distress in such person and serves no legitimate purpose. I think that's the most broad of all.
Yeah. And I think the issue there is the legitimate purpose. So, for instance, this is a political campaign that we're talking about. Does it serve a legitimate interest to the public to release that information? And I would think there's pretty strong arguments on both sides for that. But I do think overall, the idea of you being a candidate is to put yourself out there. This is who I am. This is what I
Sure.
do. That's what you're doing every campaign. I'm the mother of 2 children. I'm, vested in the community, blah, 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 blah. These are all the things I am. I'm this, I'm that. You usually talk about your career. You usually talk about your
Right.
goods and your don'ts. So you're definitely putting that out there anyways. So that's, again, to me, harass is saying there's no legitimate purpose. So, for instance, as the other side, as somebody who may be running against you or just believes what you've done is not correct,
Mm-hmm.
I think this is different, obviously, than a private thing. Private, we could talk about different. That private's a little more constrained to this word harass.
I think that's true.
You don't really have a reason. But if you're a public figure, I think you can't say somebody harassed me because they brought something out that was truth.
That you posted. Mm-hmm.
So I don't know. I mean, so for me, that'd be a hard leap for a court to make, that you are being harassed because somebody in a political context put something out about you that's truth. Is that
Found
harassment?
something you posted and reposted it.
Well, it'd be the same thing for me. Like, say it's not a picture. Say that you were a convicted felon and didn't tell anybody.
Okay.
What's the difference? I mean, do people have a right to know that you're a convicted felon? Is that harassment of you because I put the truth out about who you were? I don't think so, because you're putting yourself out there in the public eye as a politician, so you come under that scrutiny. That's why I don't run. I'm just kidding. But, seriously, you do think about those things. You think about all the things, that are out there. And so you're, now if I'm a private citizen, I don't think you have a legitimate reason to post something I did. I think it's the legitimate reasons become stumbling in the harassment case. I do.
A course of conduct directed at a specific person that causes substantial emotional distress. And I suppose that's a reasonable man's standard. It's fairly objective, not necessarily subjective. But if I have combed through your Facebook or your Instagram or your X or Twitter or whatever it is, that we really don't have any of them. But if I did and found something that I thought was maybe not something you'd want the world to see, but only a few people see, and I repost that, isn't that exactly what that is? I mean, I'm taking a course of conduct directed at you and causing you substantial emotional distress if I'm taking something that's yours and not intended to be shared. I think where the same line though gets crossed. If you shared it, I'm not sure that there's a reasonable expectation that it's not going to be reposted, reshared, just like in text messages. If I send, somebody, how many politicians right now have been scrutinized, or even public figures been scrutinized because of something they said in an article, something they said maybe in a text message, something they said when they didn't know the microphone was on and they were saying to 1 or 2 people. The microphone was on, it was recorded, and it was career-ending statements, right? I mean, those were intended to be private, certainly not to be public. They didn't even know they were being recorded, where in this situation, we're talking about somebody who knows they're recording and then proceeds to publish it to whatever audience.
Yeah, and I think that's these things are very, very fact-driven, obviously, and very, very, the other part of the statute says intimidate. What are you trying to do? Intimidate. So, to me, it's a very different thing if I text Jackie something or I text it in a group post. I think if I'm texting Jackie, there's sometimes an expectation of privacy. But here's the difference to me. So say I'm in a relationship with my wife and I love my wife and Jackie sends me an inappropriate picture. Is there really an expectation of privacy there? Is there really an expectation? It's kind of like, I always put it this way. We were talking about this earlier. Jackie comes to me and says, Scott, look, I killed 3 people last night.
I'm going from bad to worse.
Whatever. But I'm saying, she comes to me and says, blah, 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 I did all these things. And then at the end looks at me and says, you can't tell anybody. What do you mean I can't tell anybody? And people do this all the time in relationships. They'll blurt out something and then say, oh, by the way, you can't tell.
Mm-hmm.
And, if you don't understand this as a boundary issue in a relationship, if somebody has a boundary, they put the boundary first, not after they say something. So if they don't have the courtesy to put the boundary in place and say, hey, I'd like to tell you something and I'd appreciate you keeping it confident, that's a big difference between I'm going to tell you something Oh, by the way, you can't tell anybody else that.
Well, I think it's different too if that person who received the secret, okay, and then threatens, intimidates, coerces, harasses, takes that information to use it really against that person. You brought up intimidate, and Black's law says unlawful coercion. So it's kind of a repeat of coerce. Let's see, duress or putting in fear. So, clearly it would be the intent to harass someone. He would be harassing me if he took my admission of some guilt of some crime and published it, right? That would be to harass or coerce. What would be the purpose? What if he's not trying to get me to...
What if I think you're a bad person, you need to go to jail? What if that's my purpose? That's my point. So it really becomes that kind of issue, and it really becomes so fact-driven that you're like, oh my gosh. In the next part of the statute, it says any person who with the intent to coerce, harass, intimidate. Then it says maliciously, and I'm guessing maliciously in this statute is supposed to modify all the next things, which are disseminate or sell any video or still image. So it's, again, now you're getting into this word, maliciously. And I know criminally what maliciously means. What does Black say about maliciously?
Malicious, characterized by or involving malice. That's not terribly helpful. Let's see. Having or done with wicked, evil, or mischievous intentions or motives, wrongful and done intentionally without just cause or excuse, or as a result of ill will.
So again, now you're getting back to this whole thing of without just cause or excuse.
Mm-hmm.
And see, that's to me where this whole thing starts to get, the rubber meets the road. A good criminal defense attorney will take those things and spin those properly. I'm not saying so much spin, that's a negative word, but so what was your purpose? So say I'm the Republican, I guess it was a Republican operative. They didn't even say it was from somebody part of the campaign as far as I know. It was just a guy who was out there who found this. Say my purpose in reposting it was because I don't think she's a good political candidate and people need to know this truth. Have I violated the statute? I would say no.
Well, and then do you go across this little line here, maliciously in Black's, I think is a little clearer. Imports a wish to vex, annoy, or injure another, or an intent to do a wrongful act, and may consist in direct intention to injure or in reckless disregard of another's rights.
Yeah. So in a political campaign, is truth the intent to hurt?
Right.
So if I'm getting something out there, it's truth. For instance, I guess let's put another example. Let's get away from porn and that kind of stuff. Say I'm running for office.
Okay.
I'm trying to think of something. Say I can't read.
Okay.
Would that be important for voters to know? Or something else? I'm trying to think of something better than can't read, but my point is,
it makes sense, yeah.
When you put yourself out there in public and you're saying, elect me, vote for me, people have a right to know who that person is from, I think, from whatever source it may come from. Especially, like you said, especially if you put that information out there, it's already put into a at least semi-public platform.
Well, I mean, maybe you can read, but maybe you just spent, 2 stints in rehab, right? And that information is available.
Yeah.
That is information that, is it with the intent to vex or injure? Well, maybe
but
injure
then you
your
have
political
HIPAA laws
campaign.
With that, which makes it a little different. So that can be a violation of some HIPAA stuff. I mean,
But
like
if
I said,
you
there's
But if let's say it wasn't received out of the rehab you visited, right?
Yeah.
It was something you shared in a private,
semi-private,
as private as groups can be online.
Yeah.
Whatever private, members only. Okay, it's a members only group, and you said, I've been through rehab and so on and so forth, and somebody in that group then shares with the world at large, hey, wait a minute, he's running for office. I think the other side, I think people need to know that he's been going through this, that this is a part of what his current lifestyle is like.
Yeah. For me, it just comes down to, I was thinking the other day, if I was a Commonwealth attorney and somebody brought this to me and said, I want you to prosecute, I'd be like, hell no, I don't think I can do that in good faith. But, everybody's different and everybody has a different perspective. And then you start to say, okay, if I'm the defense counsel, what would I do? And that's, you got these things. I mean, there's even some, I just read a couple of the articles and let it go. I didn't try to dig too deep, but one of the things was saying something about asking for tips to do other things for a special cause. If that special cause was her election campaign, I mean, you got election law violations, you got all kinds of things. Plus, again, you take away this whole thing about privacy. You take away this whole thing about an expectation of privacy. So for me, words matter and how these things were presented and all these details are going to,
Sure.
I mean, you want to talk about a case of the century that probably you would have more visitors in than most cases ever in a courtroom. Just the facts and details of what was put out there, how it was put out there, all those things, and then how it was exposed and what part of it was exposed. Was all of it exposed? Was there a video exposed? Was there a cache of 80 videos that some were private and some were personal? I mean, listen, if you make a video in the privacy of your own home, which I think is dumb as hell, because I'll tell you what. If you do that, I'm not saying I have a problem with it. However, let me tell you, as a practitioner who's been doing this for a long time, I've had cases where the kid gets hold of the iPad.
Oh, the iCloud sharing. Absolutely.
Oh my gosh. Or just on the iPad without even having iCloud. They just forgot. They took it the night before. The kid gets up, normal course of the day, gets on the iPad, decides to go to the pictures for whatever reason, and all of a sudden he's watching mom and dad, or dad and somebody else, whatever the case may be. But that's my point. We can say that we do these things, but man, so often in our practice, things come to light that never ever had an intention of coming to light, in divorce cases and all this stuff.
Right.
And so, you know, it always amazes me that people trust that they're going to take a picture or a video or do something inappropriate on the internet and or put it out there in any kind of, let's just say with my computer, my phone, or anything like that, and somehow captured on one of those devices and think that that is secure. I don't care if you have the best system in the world. I'm just telling you.
You use an open network when you go to Panera. You use an open network when you go to some place that has Wi-Fi, and you've just opened yourself up to somebody digging through your phone on or your computer or your iPad. So I think really we've got some fairly serious takeaways today. First and foremost, your expectation of privacy. I'm not sure that there's much of an expectation of privacy when it's, first of all, even on a device that connects to the internet. Is it reasonable that it's on your phone and you would think that it's private? Sure, it's probably reasonable, but you have to have the knowledge that fact alone, that your device that has your secret thing, picture, photo, whatever it is, video,
password,
and it connects to the Wi-Fi may not be so private anymore.
Yeah, I think that's huge.
I think we've got a second issue, which is this legitimate interest. And here's why I think this is a big takeaway. Maybe there's no legitimate interest for the person who's exposed your thing. You're still exposed. Yeah. Even if they're prosecuted, even if maybe they're not prosecuted, maybe you sue them civilly for some other kind of damage, you are still exposed, right? And so whether they get in trouble for it is in my mind of less import than how you protect yourself. Our entire point today is you need to be able to protect yourself. So be wise in what you record and how you record it, and whether you use Snapchat or you use TikTok or you use your own phone and just save it in your phone under your private, secured, password protected place on your phone or tablet or computer.
Can I be cray-cray?
Yeah.
Well, why would you do that at all in our current culture? I mean, I'm dead serious.
No.
The idea that you would even, and again, I know this is a takeaway and I don't want to get too big in here, but the takeaway is, why would you have to ask yourself, why am I doing that? Slow down enough to ask your question, why am I doing this? And what are going to be the consequences of me doing this? And I can guarantee, if you're honest with yourself, there's probably not a good answer to that.
Absolutely right.
Sorry.
It's a heavy topic today. If you have questions, we'd love to answer them. And you can email us at info@cclawva.com. More podcasts coming to you soon. We look forward to spending more time with you.
And remember, we're here. If you get in a situation like this on either side and you need our help, come talk to us. We can walk you through this. We have the skills and the legal team to help you through this. These are difficult things, and we're here to help.
Like and subscribe. Thank you.
We hope you've enjoyed this episode of What to Do When. For more episodes, be sure to subscribe to our podcast, and we encourage you to check our archives to listen to previous topics. Tune in next week for a new episode and some fresh perspective from Critzer Cardani.